So I think a lot of us on this call care about liberty, else we probably wouldn't be on this call. We care about law. We care about doing what is right and what is true. So it is about the lawful and unlawful means by which government acts in depriving an individual of his liberty. History teaches that deprivation of liberty is more often arbitrary and unlawful than it is otherwise. At least this is always the tendency of those who hold executive power. All of us are probably experiencing that, or know somebody that is experiencing the out-of-control executive power. Daniel Webster once stated this problem in these words: "The contest for ages has been to rescue liberty from the grasp of the executive power." Now, obviously, I don't know exactly what Charles means by when he says the executive power, but we're really not dealing with a de jure executive power that's out of control. We're dealing with the de facto corporate structure that's out of control. Liberty is taken away or deprived most commonly by arrest and imprisonment. The practice of easy arrests and secret imprisonments has always been an earmark of a despotic executive power. To compound this problem, we have the legislative mills, which turn out thousands of new laws every year. The passion of modern legislatures to regulate every facet of the most intimate concerns of everyday life is notorious. This would be oppressive enough if administered under the requirements of a warrant or summons, but it becomes doubly intolerable if every zealous officer is authorized to arrest on sight every person whom he detects breaking one of these laws, or more specifically, I would say statutes, or corporate policy. No one can be safe to leave their home or to travel about for fear of being subject to thousands of unknown laws in which he could be instantly arrested for transgressing. One law review writer states the problem as follows: people no longer live their whole lives in the village in which they were born. They pass freely from place to place and in transit go through innumerable towns and villages. The risk of being arrested on sight because one's conduct contravenes some regulation which the wisdom of the local salons deems necessary is appalling to any thinking person. It would be impossible to know at what moment one might become amenable to arrest. The revolution in England and the revolution of the American colonies are said by high authorities to have been largely influenced by promiscuous seizures and searches of persons and property. Anybody experience that at all? I have on a few cases.
Oh, yeah.
The history of our ancestors over the centuries teaches that a people cannot be free where the executive power can arbitrarily arrest or imprison citizens, or ransack at will the properties of the people. The executive power is limited and guided by the law of the land or due process of law. If it was a restriction upon the King of England, it must be so for every petty officer today. So he goes on, he says, in many of the treatises on the law pertaining to the rights of citizens, and many of the older and better court cases, we find the declaration: the law is very jealous of the liberty of the citizen. So what is the law that so regards liberty? Maria, you'll like this. It is common law, and it declares that one who interferes with another's liberty does so at his peril. Now, for those of you who don't have this treatise, Charles Weisman does a lot of quoting from cases, court cases, and law books and such like that, and he puts as a footnote down in at the bottom of the page. I'm not going to go through those. Again, anyone who needs this, just contact Maria, and she can get the PDF out to you so you could look at that yourself. So I'm going to continue here. It also prescribes how arrests are to be made. So now we're getting into, let's see, Chapter 2, where now we're going to start getting into the meat of it. The title for Chapter 2 is Definition of False Imprisonment. So what constitutes false imprisonment? false imprisonment consists of any type of unlawful restraint or interference with the personal liberty of an individual. That's pretty straightforward. It basically involves any unlawful violation of the liberty of another. The ancient English legal scholar Henry de Bracton in the 1200s tells us that false imprisonment is one of the oldest violation of rights known. So this goes back pretty far. Forcefully to deprive a man of freedom to go wherever he may is clearly a trespass. False imprisonment was indeed one of the first trespasses recognized by the common law. So false imprisonment is classified as a tort under common law and also a crime. Now a tort, now I'm going off the page here. A tort is a wrongful act or a infringement on a right. That's what a tort is. So it has been labeled a tort, a trespass, an assault, a wrong, a damage, and an injury. So all these things are under false imprisonment. Let me say that again. False imprisonment is classified as a tort, which is a wrongful act or infringement on one's liberty or rights under the common law, and also a crime. It has been labeled as a tort, a trespass, an assault, a wrong, a damage, and an injury, giving one cause to bring suit against another for remedy. This is what we need. Depriving a person of their liberty is legally no different than depriving a person of their property. A theft of liberty is a wrong by which remedy can be had, just as in the case with the theft of property. False imprisonment is a great offense due to the high regard the law has for liberty. Now, he makes some references to some resources that I've never heard of, but nonetheless, I mean, if one was to go into a law library, I'm sure they could verify these quotes. In Chitty's Practice of Law, it states, the infraction of personal liberty has ever been regarded as one of the greatest injuries. The injuries to liberty are principally termed false imprisonment or malicious prosecutions. Interesting. Unlawful detention or deprivation of liberty is the basis of an action for the tort of false imprisonment. On a side note here, after reading this treatise and studying other things, I have come to the conclusion that when a corporate policy enforcer puts on his lights to pull us over, in that moment our freedom and our rights are being infringed. He is now entering into a felony by doing that, and he is now engaging in false arrest and false imprisonment. And Charles is going to go into later into this treatise to show how false arrest and false imprisonment starts the moment it happens. It's not like false imprisonment happens when you're thrown in jail, or false arrest doesn't happen when the cuffs are put on you. No, false arrest and false imprisonment happen the moment that our rights are infringed. So we need to keep that in mind. I'm going to get back to the treatise here. Actual seizure or the laying on of hands is not necessary to constitute an unlawful detention. There doesn't need to be any physical contact. Thus, the only essential elements of the action are detention or restraint against one's will and the unlawfulness of such detention or restraint. Now, I don't know if we'll go into it in this call, but I was at the law library about a week and a half ago because I wanted to start verifying some of these things in this treatise, because I like to be careful when I'm reading quotes, especially quotes from court cases or definitions from regarding certain aspects of law, because I've come across sometimes where the quotes were wrong, or they weren't even in the resource that someone quoted from. So it's really incumbent upon us, very wise if we did verify some of these things. So like I said, I went to the law library and looked up false imprisonment and false arrest, and I got a lot of information of court cases that talk about this very thing. And it's interesting how some cases from different states and also federal cases the way they define the elements of this kind of prosecution. I have to understand, like, if one aspect when you're dealing in a court case, in order for the moving party to have a valid standing in a court, for the court to have jurisdiction, they have to have a valid cause of action, and within that cause of action, they have to have certain elements that cause of action it requires, and all those elements need to be satisfied. So it's kind of good that he gives us the elements for the cause of action, because if you don't have that, there's no case. That's a good defensive argument, but if we're going on the offense, we need to know how that works. So anyway, back to the treatise. So in his treatise on law of torts, Judge Cooley states, false imprisonment is wrong akin to the wrongs of assault and battery. Wow, that's interesting. And consists in opposing by force or threats an unlawful restraint upon a man's freedom of locomotion. That sounds awfully familiar, doesn't it? Isn't that what the corporate policy enforcers do? By force and threats, they try to, well, you know the rest of it. So Blackstone, in his commentaries on the law, states on this matter, every confinement of the person is an imprisonment, whether it be in a common prison or in a private house, or in the stocks, or even by forcibly detaining one in the public streets. Thus, any type of detainment or confinement of a person, or restriction or deprivation of their liberty or freedom of locomotion, where he is compelled to remain where he does not wish to remain, or to go where he does not wish to go, is an imprisonment. The only question thereafter is whether or not the imprisonment is false. The word false comes from the common law and is synonymous with unlawful. A false arrest is one means of committing a false imprisonment. In describing false imprisonment as being the unlawful restraint of the liberty of the citizen or the primary right of freedom of locomotion, the Supreme Court of Idaho also stated, imprisonment is any restraint of the personal liberty of another, and prevention of his movements from place to place, or his free action according to his own pleasure and will. It is false imprisonment when this is done without lawful authority. Now keep those two words in mind, lawful authority. We start looking at some of the cases that were in the American law of torts, where I got the definition for false arrest and false imprisonment. Like I said, there's a lot of cases. Some cases refer to legal authority. Now, as we go through some of those quotes, we're going to see that the courts are not unanimous, nor are they congruent with one another in how they say that, the conditions of a false arrest and false imprisonment. Some refer to, without lawful authority or legal authority. Just keep that in mind. So back to the treatise. In reviewing several textbook definitions on false imprisonment, the Supreme Court of North Carolina stated, false imprisonment is the unlawful and total restraint of the liberty of the person. The imprisonment is false in the sense of being unlawful. The right violated by this tort is freedom of locomotion. Because that's where I think most of us, most of the time, are going to experience this, is when we are in our private property going from point A to point B, and a corporate policy enforcer pulls us over and we get wrapped up in all that. Back to the treatise. It belongs historically to the class of rights known as simple or primary rights. The theory of law is that one interferes with freedom of locomotion of another at his own peril. So we can see how important this is because, again, I mentioned this earlier, these policy enforcers, every time they put their lights on to pull somebody over, they are at that moment committing felonies. And they do it at their own peril. And one could say to them that, ignorance of the law is no excuse, because they're required to know it as well. So back to the treatise. A rather complete description of what does and does not constitute false imprisonment was given by the Supreme Court of Kansas as follows. This is a little lengthy, but nonetheless, I'm going to go through it. False imprisonment is necessarily a wrongful interference with the personal liberty of an individual. The wrong may be committed by words alone, or by acts alone, or by both, and by merely operating on the will of the individual, or by personal violence, or by both. It is not necessary that the individual be confined within a prison or within walls. I mentioned that earlier. Or that he be assaulted or even touched. So there doesn't even have to be violence there. It is not necessary that there should be any injury done to the individual's person or to his character or reputation. Nor is it necessary that the wrongful act be committed with malice or ill will, or even with the slightest wrongful intention. Nor is it necessary that the act be under color of any legal or judicial proceeding. All that is necessary is that the individual be restrained of his liberty without any sufficient legal cause. There we go. See, this court uses legal cause rather than unlawful authority. Therefore, and by the words or acts which he fears to disregard. So it'd be interesting to know what the man or woman in the black robe meant by legal. False imprisonment exists not only by words or acts that one fears to disregard, but also by such acts and measures that he cannot disregard. No fear of disobedience need to exist. If someone causes a situation that makes it impossible for another to exercise their liberty or locomotion, it is false imprisonment. False imprisonment is the name of the category for those torts. Pop quiz. Does anybody remember what tort means? Anyone want to take a stab at it? A wrongful act or an infringement on someone's right or liberty. So where was I? Here we go. Under this category, the unlawful arrest is the most common type of wrong committed. Another common way in which a wrong of this nature occurs is by the unlawful detention of a person in a room, jail, or other location. Definitions of false imprisonment usually come from unlawful restraints of this nature. Here is another quote. False imprisonment has been well defined to be a trespass committed by one man against the person of another, by unlawfully arresting him and detaining him without any legal authority. Now, I have a problem with that word as of right now when these quotes use legal. That has to be looked at a little deeper. The law sets such a high value upon the liberty of the citizen that even an attempt to unlawfully arrest is esteemed a great provocation. It's pretty interesting, isn't it? Before I read this treatise, I didn't have any idea that, I know the law is on our side, but this is pretty serious. All the authorities agree that an arrest may be made either with or without any physical force or actual touching by the officer. We know that today. If any of you watched any YouTube videos, we know that people are about their business and they just get hassled by police officers. It may not be intentionally going after them for anything that's wrong, but as long as they are detained for 1 second, they are under arrest and imprisonment. Thus, any legal restraint of one's personal liberty by the act of another gives that person a cause of action for false imprisonment against the one causing the illegal restraint. Prima facie, any restraint put by fear or force is unlawful. False imprisonment is necessarily a wrongful interference with the personal liberty of an individual, usually made by an arrest or physical custody, or restraint is not essential to the effectuation of an arrest. Well, that's pretty cool. So if an officer tells a person that he is under arrest and he thereupon submits himself to the officer, going with him and obeying his orders, such person is deprived of his liberty. And if the act of the officer is unlawful, it is false imprisonment. In all cases in which there is no physical touching or seizure, nor any resistance, the intentions of the parties to the transactions are to be considered. In such a case, there must have been intent on the part of one of them to arrest or restrain the other, and intent on the part of such other to submit under the belief and impression that submission was necessary. How many times do we, for those of us who had to deal with corporate policy enforcers, when they order us to do something, we would have to submit because either we think it's necessary or it's under threat, coercion, and duress. Back to the treatise. The following definitions will provide further insight into the nature and elements of false imprisonment. His definition. False imprisonment is the unlawful restraint by one person of the physical liberty of another, and as here used, the word false seems to be synonymous with unlawful. So, in this chapter, it's really hammering home the same point. It's almost, in a sense, ad nauseum, but just be patient with it and get through this. But nonetheless, it's good stuff. Here's another one. Any exercise of force or expressed or implied threat of force by which, in fact, the other person is deprived of his liberty, compelled to remain where he does not wish to remain, or go where he does not wish to go, is an imprisonment. We read that earlier. False imprisonment is the unlawful arrest or detention of a person without warrant or by an illegal warrant or warrant illegally executed. Here's another one. Any restraint, however slight, upon another's liberty to come and go as he pleases constitutes an arrest. So now we'll just stop there. If anybody has any questions or comments or wants to explore this a little better before we move into another part of this chapter.
I was wanting to look at that paragraph you just read. False imprisonment is the unlawful arrest or detention of a person without warrant, by an illegal warrant, or a warrant illegally executed, and that seems to be the most common way it's done. It's if there is a warrant, it may be illegal, and when they come to do the arrest, the warrant's illegally executed. So I wondered, is Chris here?
I don't know. I don't know his phone number offhand.
I'm here.
Oh, okay, great.
Okay.
Mary, did you want to...
Yeah. So that paragraph, did you hear that, Chris? Unlawful arrest. And I thought maybe you want to go through kind of the sequence of what happened as it relates to that paragraph, the without warrant, illegal warrant, or a warrant illegally executed.
Absolutely.
Sounds like it has your name on it, yeah.
Exactly, and I think that anybody that has been served a warrant in our country has absolutely probably been served an unlawful, fraudulent warrant. Upon my specific situation that happened Sunday prior, a week prior from the last, they surrounded my truck as I was pulling out of Denny's. We were having coffee on the way to an assembly meeting, a lawful assembly meeting, and surrounded me with 6 to 7 trooper cars, all of which jumped out and pulled SWAT weapons on me, rifles, assault rifles, and they demanded me out of my truck. At which point, I pretty much know that at that point, if everybody got SWAT, they're looking for you, and you better follow through because they don't like me anyway, and they assume that I don't like them from prior contacts. Continued to deny a warrant, and I know I had repeated it at least 6 or 8 times minimum. I had asked for the sergeant who was there. He came over and continued to deny me lawful Article 2 warrant and to produce it. They never read Miranda rights. They threw cuffs on me very tightly, causing me pain, and put me in the car in one of their cruisers, at which, the time and all the way through until they got me to booking at the local for-profit corporation known as the FCC, or part of the Department of Corrections in Alaska. I continued to ask for that lawful warrant to be produced, of which nobody would do it. And then right before they stuck me in front of an arraignment, which is supposed to be due process, I'm sitting in front of a video camera looking at a picture of a court, listening to people from who knows where. Who knows if they're even legitimate people? You know, one of the first things they did when I was there was they took voice recognition patterns so I could get set up so I can make a phone call. And if they got the technology to do that, they've got the technology to deny us of our rights by just having a computerized artificial intelligence to do this to us. That's a whole other aspect that needs to be explored. They're using this COVID as a reason to roll in this technological takeover. So even whenever they served me the fraudulent warrant with the only affidavit that was attached to, which was sworn by a second-hand person, an officer of the Alaska State Trooper Corporation, a private for-profit mercenary force. That's their words pretty much, as on their history site on the State of Alaska webpage. Private authority for hire. Clearly what it says right there. I think that's pretty much word for word. So I looked at that warrant, and I knew it was completely fraud, and whenever the magistrate started talking to me, I objected, as I priorly did to their jurisdiction, and I also challenged their assumption of 14th Amendment citizenship, of which I've priorly done. I've taken many steps over the years to expatriate myself from them, and they know it. The State Trooper Corporation had even been noticed. I'd served them notice of liability on a prior occasion for their crimes against me. You know, it's exactly what you're saying, and it's exactly what's in this Arrest and False Imprisonment Treatise. It's exactly what we're facing.
Yeah, I was thinking after I went over this again about the warrant. They're a corporation, so, and this may be more rhetorical. It's more of a question, just provoke myself to think, or maybe you guys out there to think. If they're a corporation, there's no authority for them to even issue a warrant in the first place. So I don't know if anybody has anything they want to, if they have anything to say regarding that, because you break it down to it's simple. I like to break things down to its simplicity because it helps me grasp things a lot easier. So we have this thing called a warrant, but then you have everything behind the warrant that there has to be a proper, lawful, authoritative process to administer that warrant, but it has to be from a proper authority. We're not even dealing with proper authorities. They don't even have authority in the first place. So, I mean, even if they did produce a warrant, they don't have the authority to do that, let alone, even being concerned with it meeting the lawful requirements of a warrant. Does that make any sense? It's just something to ponder. I'm just, it's like everything else with this whole de facto system, this Wizard of Oz system that is, darkening the land, or darkening the world, actually. So anybody else
something to say? Yeah, I got something to say. This is Dave Bartels. And we've already got both our governors. So we got the law, and we got Frank Murkowski, former governor, and the current governor, Dunleavy, to essentially admit the court system is not the judiciary. We have evidence of the whole system. They're doing it globally. They're all private authority. And so I have evidence, even from the Supreme Court of Alaska, this scheme of the executive, if you will. They're private authority, but they're executive, of issuing warrants was settled way back when as unlawful. See, so they shouldn't be called courts. They shouldn't be called judges. They shouldn't be issuing warrants. Some of it, what I call them, is like their writless action. When they do a complaint, that's by a private person, where information is by a public officer and presentment indictments done by a grand jury. So they're all private authority doing this, and then what they want to do is conceal it and or not admit what's really going on. So once you know the truth, you can debunk them, but then they want to go silent. That's what I've noticed, that basically all the judges, when I help people, they're getting up and leaving the bench or going silent, or they get mad, and they shouldn't be, because we're not being improper conduct. they're just trying to screw you and they get frustrated.
Well, that's par for the course. You know, that for me personally,
Yeah.
that doesn't surprise me.
All this stuff they say they're the Alaska court system right on the building, but then they don't say they're not the judiciary. Therefore, we have no judicial power to enforce anything. And I already got them to admit it down there once, and I want to go record them, but this stupid COVID's going on, where I didn't think the clerk would know it, so I didn't record her. And just the way the law works up here, I said, let me ask you a question. In these criminal cases, after they do a judgment, is there any process? And she got this big smile on her face and looked down and goes, no. And the friend that was with me, his eyes just about bugged out of his head. I said, see, I told you they're putting everybody in by consent.
Yeah, this information needs, and that's important about this information getting out.
And as the person. So I've been working on the simplest process is I got this person all decoded and how you interpret, how the statutes are interpreted, and the standard is by clear and unquestionable authority of law. And statutes are construed strictly, they can't be extended, they're against the government in favor of the accused, and then right before all that, well, let's get it, you're outside the common law because none of your so-called statutes demonstrate they even modified the common law. You know.
I'm sorry, your name was Dave, right?
Our system. Yeah.
Hey, Dave, is there any way you can get that information out to us? Maybe you could send it to Maria, and Maria could send it out, the correspondence you had with the governor and those other things.
Yeah, Chris has all that. He said he even posted it. And then
I'll read out.
We're getting the information on decoding the statutes just to show the crime they're engaged and the fraud they're engaged on the people.
I can right now tell you exactly where to find both of those videos because they were recorded and auto-recorded and they were posted on YouTube. The first one that was done that he's speaking of, that you will hear his voice and him speaking to Frank Murkowski, is on a YouTube channel called Freedom, spelled properly, LVR, Freedom Lover, all together, and search for Let's Ask Frank. That's the video with Frank Murkowski. The second video where Mr. Bartels and I, sorry, I'm not calling you Mr. Bartels there, and I were in front of the Governor Dunleavy about, this was approximately 3.5 months ago, maybe 4 months ago now, in Big Lake, Alaska, where he clearly states that the Alaska court system, also known as Department 41, to lose trackability and understanding of who they are and why they're under the executive branch, he clearly states that they are under his authority. And in any real-world situation where we had lawful, good, clean media, that would be global news. And you can find that at my YouTube channel called Renaissance, Permstead, Permastead, and Apiary, spelt like the bees, Apiary. And I've only got about 6 or 7 videos on there, so you'll see it. It'll say like Dunleavy something or other. And I know I'd had quite a few videos hits on that, but they keep knocking it down, saying that there's only like just a few hits on that.
Hey, Chris, is there any way maybe you could get some links out just for maybe some of the people that weren't able to write down that information?
I can. I'll forward those to you.
Okay, great. Yeah, I mean, there's plenty of information out there that the truth is on our side. It's just a matter of us learning it and bringing it out into light and applying it. When I was arrested back in June, I wasn't put into jail, but I was zip-tied. My hands were zip-tied behind my back and put in a cruiser. And I was basically telling those guys that they have police on the side of the car. I said, you guys aren't police officers, because that word is really pronounced policy. You're just policy enforcers for a corporation. And they were just like scratching their heads. They didn't know what to think. But nonetheless, you know, we need to, like I said, just hold that truth out and stand on it. Is there anybody else? If not, I'm going to get into the next section of this chapter, and then maybe we'll wrap it up in a little bit.
Peter, I've got the Let's Ask Frank, and I'll send it out to everybody. The one thing I wanted to say about that, a warrant that came through on Chris's, finally came through to Chris. Chris, I guess it was while you were in jail that they finally produced the warrant?
Literally, they handed it to me just before I was walking in for an arraignment, for that thing that they call an arraignment.
Okay, that was a day later?
No, that was that afternoon.
Okay.
That
All right,
Sunday that they put me in.
Okay, and then it had attached to it an affidavit, right?
Correct.
Okay, and that was, you read most of that to us today, and the thing that was striking to me was it was sworn affidavit by one of the arresting folk, and he has no firsthand knowledge. So, and then I'll add some more as we go through about how we knew that the warrant and the affidavit was unlawful as we go, Peter.
Yeah, we're going to address, actually, Charles addresses that in the next chapter and also in chapter 6. He gives all the specifics regarding the warrant and the requirements for the warrant. But that sounds kind of fishy that the officer produced an affidavit and he signed it. Well, doesn't the issuing authority, quote unquote, the issuing authority, aren't they responsible for signing the warrant, not one who submits an affidavit? So that doesn't even make sense to me. But then again, everything they do doesn't make sense, and that's their Achilles heel.
Well, and I think the most egregious part of it really is it's a Class A misdemeanor, and they used a SWAT team. There's a problem there. Something's going on behind the scenes.
Excuse me?
Who's that?
This is Dave again, and I wanted to just say one point because I told you, Maria, but not when Chris was on the line before. See, before all this, he should have had his day in court over the issue before they did any of that, just to eliminate all this. There's no emergency there. So they should have cited him to appear to defend against the allegation before they ever charged him.
Right. And Weisman goes into that as well, which, I totally agree with you. So, we'll get to that later.
Before you're deprived of your liberty, that's why that other branch is supposed to be there to also protect you from this kind of stuff. But that's the nature of usurpation. That's what they got to do, is get away from the truth and get away from the lawful procedures in order to do what they're doing, or they couldn't do it.
Right.
So you got to bring it back in. Hey, this is where you denied me due process of law. It means my day in court before I'm deprived, not afterwards. You can't undo it.
Yeah, their livelihood depends on the fraud.
Yeah. Oh, yeah. That's what they got to do, is get away from the truth and get away from the lawful procedures and everything, or else they're like bound to, keep us free. They got to do the opposite.
Yeah. And there's some on this call that have already experienced checkmating these people to where they were neutralized. I mean, I've done it. Chris, you're in the process of doing it, and this is not the only time. Maria, you've done it. So, but some of you on the call that may be new to this, there are results, there are remedies. So it's not hopeless, and that's why we're going through all this. All right, would you guys like to continue on?
Yeah.
Okay. All right. The next section is chapters called Length of Time Requirement. So the tort or wrong, tort again is a wrongful act or an infringement on man's authority. The tort or wrong of false imprisonment occurs the instant that one is restrained in the exercise of the liberty. There is no unreasonable length of time for a restraint before the tort can be claimed. So Chris, obviously you could claim false imprisonment the moment they stopped you. False imprisonment at common law and elsewhere consists in the unlawful detention of the person of another for any length of time whereby he is deprived of his liberty. And that's in I'm going to see what that's in a court case as well. That was a quote from a court case. Where two people are traveling in a car and stopped by police, and the party not driving is put in the police car and told to wait, the officer doing so is guilty of false imprisonment. So, Chris, what was the woman's name that was with you? Sherry?
Yeah, Shelley. She runs a news channel on YouTube and other platforms from here in Goldstream. She's a good friend, and she's also on our Alaska General Jury Assembly that we've been forming.
So I think Maria,
she was cuffed for a period of time, as well as she was partially in the cruiser whenever they pulled her right back out.
Yeah, Maria shared. She opened up a phone call where Shelley was telling us. I think it was the day it happened, right, Maria?
Yep, it was.
So my point is, even Shelley has a case for false imprisonment. Where are we at here? Back to the treatise. Even though the person was in the police car for less than a minute, it was an arrest, as the officer had no authority for confining him or her in the car. Even where policy officers stop a moving vehicle for a brief detention, it is sufficient to constitute an arrest. That's why I said earlier, the moment they put their lights on to stop you and pull you over, we are under arrest. Where one is told to stay in their car by an officer, though it be only for 10 seconds, it is an arrest. Time duration is not a factor in making an arrest. There's another quote from another court case. False imprisonment is defined as an act which directly or indirectly is a legal cause of confinement of another within boundaries fixed by the actor for any time, no matter how short in duration, makes the actor liable to the other. So when one is approached by an officer and questioned about his identity and actions, this is only an accosting, not an arrest. All right, so the next section is chapters damages and liability. One who interferes with another's liberty of locomotion does so at his own peril. We read that earlier. All who do so without lawful authority can be sued for the trespass upon liberty and loss of time. It thus is a very serious thing to deprive a person of their liberty. Since false imprisonment is a wrong suffered by a person, that person is entitled to receive a remedy for damages. And like I said earlier, this is, I think, is a great vehicle for us to go on the offensive. Not only is a person entitled to receive a remedy for the deprivation of his liberty, but also for any other damages that are a result of that deprivation. False imprisonment was an indictable offense at common law, and relief by the party aggrieved was obtained by an action for trespass, and there's some Latin term, viet armis, which means with force and arms. That comes from another court case. Let me see here. Yes, another court case. So the illegal arrest of a person without a warrant or under an invalid warrant entitles him to compensation for the damages sustained by reason of the false or unlawful imprisonment. Now, I just want to interject here. Later on in the treatise, I think Charles goes through he goes through the paperwork I think he used in a couple of cases. So it gives us some idea of, even how to do paperwork. Where am I at here? Here's another quote from a court case. The general rule of damages in cases of false imprisonment is that the person causing a wrongful imprisonment is liable for all the natural and probable consequences thereof. The plaintiff is entitled to recover damages for what the party wrongfully did. In an action for trespass, assault, and battery, and false imprisonment, the court held that the plaintiff could recover not merely for the time the constable was bringing him to jail, but for the whole period of his imprisonment. So, Chris, you should really make out on your case. Here's another one. The court said the arrest being wrongful, the defendant is liable for all the injurious consequences to the plaintiff which resulted directly from the wrongful act. It's good stuff. Quote, unquote. Unlawful interference with or injuries to the liberty of a citizen is a violation of his natural, inherent, and absolute rights, which damage results as a legal consequence. These are all quotes, again, that Charles is giving us. Here's another one. A false imprisonment generally includes an assault and battery, and always at least a technical assault. An unlawful arrest, imprisonment, and prosecution of a person can cause that person many damages, including bodily pain, great physical inconvenience and discomfort, loss of time, mental suffering, injury to reputation, distress or anguish, humiliation of mind, shame, public ridicule, invidious publicity, and public disgrace. Some of these damages overlap to some degree, but all can and have been claimed in false imprisonment suits. We have a little bit here to read until the next section. I think I'm going to finish that, and then we'll just finish up for the excuse me, finish up for the evening, and we'll pick it up next week. Upon the subject of damages, the law specifies two kinds of damages, or divides them into two classes. There are what are called actual damages. Then there are what are called punitive damages. So actual damages are such compensation for the injury as would follow from the nature and character of the act. They are the damages for wrongs received and injuries done when none were intended. In a false imprisonment, they can include the pain and suffering which the average citizen would be supposed to suffer under such circumstances. They further can include the physical discomfort and sense of shame, wrong, and outrage. These are all also called compensatory damages, as they compensate the injured party for the actual injuries sustained and no more. A couple more paragraphs here. Punitive damages are those that grow out of wantonness or atrocity or aggravated by the act. They are injuries and sufferings that were intended or occurred through malice, carelessness, or negligence amounting to a wrong so reckless and wanton as to be without excuse. These are also called exemplary damages. So punitive damages and exemplary damages are apparently similar. Anyone who assists or participates in an unlawful arrest or imprisonment is equal liable for the damage caused. So how many de facto policy enforcers that you encountered, Chris? Was it 7 or 8?
Yeah, approximately 6 or 7 of the ones I saw.
So apparently, according to the law, they're all culpable. Thus, where a man was illegally arrested by a policy enforcer and was placed in a patrol wagon in which he was taken to the central station, it was held that the 2 officers in charge of the patrol wagon were liable, along with the arresting officer, for false imprisonment. That ends that section. The next section is malicious prosecution, which I think maybe we'll pick that up next week. Does anybody have any questions?
Driver's license that he was going to arrest me. So I was going to try to I got the recording now of it, and I was going to make a meeting, see if I could get a meeting with him and his supervisors on this authority to be arresting people. And what I was hitting them on is they can't prove who it applies to. And I said, do you understand the insanity that you're out there charging people with statutes and you can't prove who they apply to? I said, have you no shame?
Yeah, the first time I was pulled over, which was several years ago when I first started getting into this, and because I don't have a driver's license or a registered car or anything like that, and the guy who pulled me over, this is before I knew about all the this false arrest and imprisonment. The guy who pulled me over, he goes through a spiel asking for driver's license, insurance, registration. I go, can you tell me what the lawful definition of a license is? He looked at me like a deer in headlights. I'm like, you're supposed to be a law enforcement officer, and you can't even tell me what a definition of a license is, and you ask me to produce it to you? I'm like, beat it. So he ended up, he called the sergeant in, and he goes back. There was 2 other cops that was brought in, in the car behind me. So he goes back to the car behind me. And he comes back 10 minutes later. He goes, oh, it means permission. I'm like, get out of here, man. You should know this already. So it's good stuff.
And why would we need permission when all the power comes from us? And just so you know, you might want this just for the heck of it to have it. Our Constitution up here, it's been in there for 18 years, and Jack Coghill was a former lieutenant governor, delegate at our Constitutional Convention, a longtime senator. The very last line, it's called Introduction to the Constitution, the very last line he says, please read it and understand its continuing dedication to you as the governor, not the governed. So I tell people like they're laughing at us. Everybody's brain dead to the law.
Well, yeah, that's why things are the way they are. Oh, by the way, that same incident, the sergeant, he's imposing statutes on me, and I kept challenging him to prove how I'm subject to those statutes. He got so mad at me. He goes, you know what? You're in my town. I'm the law. I just looked at him like, you're out of your mind, dude. You're out
That's what I was telling him. Yeah. We're the county. We're the state. We're the government. Yeah.
All right, so.
And all that was, I was just pulling out of a private driveway. It was at night, no traffic, and he just saw headlights, and he was trying to say that I didn't stop at the end of the driveway before I entered this Big Lake Road, it's called.
He was probably trying to.
He said, here's the regulation. And I said, a regulation for government. Is it a substantive regulation? And I said, it wouldn't apply to the people, but it could apply to the public, whatever that is. So they deleted all that out of their audio, the whole front end, but I still got good stuff in there. I'm one of We the People, and they are. Just so you know, I don't know if things are changing, but I do know I felt it as a gift. Not the last trooper that I talked to, but the last 4 before that, all admitted they knew the government was overthrown, and they're pretending we're not the people who get control over us.
Wait, I'm sorry, say that
We're
again?
in the past. They don't just... They admitted they knew the government was overthrown, and that they're pretending we're not the people to get control over us.
Oh, man.
I got one of them on audio, so I'm going to start trying to record them. And I think what happened on this last one, because I brought it up, I said the government's overthrown, correct? And he wouldn't go there. But I think it was 2 where the other ones were way more relaxed. Very calm, non-alerting. And I tried different approaches on it just to see what works. But that's what's going on.
It's amazing how all these people are just treasonous. They have no problem being treasonous.
Well, all goes back is don't want to lose my job.
Yeah. I like my pension.
So sorry we got to kill you.
Yeah.
Sorry we got to break the law and imprison you and violate your rights, commit crime on you, but don't want to lose my job. Nuremberg defense, right?
Yeah. Well, they get a lot of benefits and pension, and it's sitting pretty good. That's a great motivator, and that's the problem.
I did a Facebook post. I don't go for a lot of friends on Facebook, don't do a lot of it, but I did a little excerpt on that, how we're trillions and trillions and trillions and trillions in debt, more people incarcerated in the land of free than any country in the world, and not one person I know of in government is objecting to it.
Well,
what's wrong with that picture?
There are no people in government because there is no government. Anyways.
It's acting. I understand.
Yeah.
Anybody else? Looking for remedy, I tell everybody. That's the bottom line, right? Without remedy, it doesn't matter how much bad stuff you know or how much you know about the law. It's like we're looking for remedy. So I keep streamlining it, and I'm going on this insanity with all the info I have. They can't prove who the statute applies to. And then to explain to people that Supreme Court case was in 1969 of Alaska, but the other one, it goes back over 80 years, and not one of these members of the bar, which is all the judges, state and federal, Supreme Court justices, state and federal attorney generals, magistrates, deputies, all these, millions of these lawyers have let the treachery, crime, reign for over 80 years on the people. That's what you're dealing with. Because once you know the truth, they go silent, right? Typically.
Well, sure.
They're not going, oh, yep, you're right. Or let's get to the bottom of that. Hey, let's everybody have a hearing on that and get all the evidence for it. Boy, we got to ascertain the truth.
Well, I like to equate it with the Wizard of Oz. You know.
Yep.
Frodo's pulled back the curtain and they're exposed. So they don't want to be
Satan's
exposed.
there.